Hi, welcome to the end of life journey and beyond, the sands of time. My name is Lisa Strauss Lawrence.
Hi, Lisa. I'm Susan Caperso, End of Life Doula, and we're so happy today to introduce a guest, Brian Tully. Brian's from Millville. He's a certified elder law attorney. He's been practicing there 23 years. He's the founder of Tully Law Group. Brian specializes in estate planning and a more comprehensive life care planning, which is not just for seniors, but as we talked earlier, people have been coming in a little bit younger to get all of their affairs in order, so to
Mhm,
speak.
mhm.
So Brian covers legal, financial, and care advocacy issues of aging. And I've known Brian for quite some time. He offers so much here in New York, and I'd love you to get a chance to know Brian today. So welcome, Brian Tully. Thank you for joining us.
Thank you, Susan, Lisa. Very nice to be here. Thank you both. Um, it's an honor to be here to share in what you're doing. Very, very important issues, and hopefully people are paying attention, and hopefully people are taking from you what they can, because it should no longer be taboo type issues. It should be issues to help them to celebrate what's going on in their lives. So
Absolutely.
whatever little I can contribute, here I go. And please, let me know if there's questions as I go.
Sure.
Um, so as Susan shared, I've been helping families for 23 years when it comes to estate planning, when it comes to elder law issues and aging issues. And what I have found throughout the years, and just to kind of summarize, there's three different aspects that we help people, which I believe kind of round out the issues that people are going to face and endure as they age. And that's the idea of estate planning. It's the idea of protecting and preserving your assets and your income, as well as the care aspect of what's happening, custodial care, long-term care, hospice care, end-of-life care, etc. So when we meet with a family, we are certain to broach those three topics of planning, protection, and care, so that we can round out the aging picture and really help them as they journey through the what we call the elder care continuum. So to talk about each of those just a little bit. Um, Estate planning itself is not just for the wealthy. It's not just for the millionaires down, in the city. Estate planning is for everybody. It's for those. We've worked with families that rent a house and have $40,000 in the bank if they're lucky. So we've also worked with families with 20 million. So there is the concept of estate planning is for every adult. The purpose of estate planning is to not only, what people typically think of is they're like, well, who's going to get my stuff when I'm gone? Who's going to inherit the house or the money? That's part of it. But estate planning is primarily two parts. Who's going to inherit when I'm gone? You could also decide how are they going to inherit. You can also decide when they're going to inherit. So there's more to just who. But the second part of estate planning is also who's going to help me if I need help later on. So there can be an incapacity issue physically or mentally. And there could be a legal need, there can be a financial need, there can be a healthcare need. And that's what I'm going to spend most of my time talking about today. But I'm going to jump to the other two parts, explain and round out the picture, and then I'm going to come back and spend a few minutes on that side of planning. The second avenue that we go down with folks is the idea again of asset protection, income protection. Now, the reason we do that for families and the reason why it's so very important to do this while you're doing the estate planning is because as we get older, the reality is that we're going to have certain things happen to us, medical things, chronic things. For example, if you go to a doctor or a hospital or a rehabilitation center for physical therapy, those are all medical in nature, and therefore they should be covered by your health insurance or Medicare and your supplemental mostly. But on the other hand of that coin, you can have issues that are not medical in nature. You can have some that are what are called chronic or functional. And it's those activities of daily living that describe the non-medical needs that we can have. So for example, if you just need help getting out of bed, it's called transferring, walking, using the bathroom, bathing, toileting, dressing, grooming, eating. Those are those activities of daily living. And when somebody needs help with that type of care, it is not medical, it's long-term care. And since it's not medical, then guess what? Your Medicare is not paying for it. So when somebody needs help with from an aide in their home to help walk and bathe and toilet, it can be very, very expensive. If somebody, God forbid, needs to go into a nursing home, it's twice the cost. The home care scenario can be a couple $100 a week to about $2,000 a week or more. You're looking at about $10,000-$11,000 a week for home, forgive me, a month for home care. Nursing homes are $15,000 to $20,000 a month. People can't pay for that themselves. So there's three ways in which you can pay for this long-term care. You can utilize your own private funds, which I just said is very limited for most people, or if you have a comprehensive long-term care insurance policy, or Medicaid. So Medicaid is the government program that can pay for your long-term care needs in the home or in a facility, as long as you're eligible. And today's not the time to get into all of those eligibility rules, but understand Medicaid's out there, but that's why we need to protect. So we talk about asset protection for everybody over 60, 65 years of age, because we have those look back periods and we have those waiting periods. So again, a big chunk of our help that we give to our clients is helping them plan and protect for the future. The third part of what we do, and quite honestly, this is the one that's closest to my heart and just as important as the planning and the protection, is the care itself. As I've told clients, if the care isn't the best it can be, what's it all for? I mean, what good is it to save the house or the $100,000 if dad or mom is not getting the best care possible? So about 12 years ago, I recognized and realized, maybe 14 years ago, that there's more to what I do as an elder law attorney. It's more about the care issues, which is why we call ourselves elder care attorneys. So what we do is we have geriatric social workers on staff. We call them elder care coordinators. And their job is to literally team up with our clients, our elder that's in need of help, and assess the situation, intervene if there's any type of crisis, coordinate the providers and the benefits, and to advocate every step of the way. In addition, they're supporting the caregivers and the family through the entire journey. So it's an all hands on deck type of approach, okay? So again, three main things to focus on as we get older: planning, protection, and the care. So that's the protection and the care. I'm going to get back to the planning because that really focuses on how we can get people to help, how we can appoint people to help us as we're getting older. So I said that when it comes to estate planning, there's two parts. First part is the inheritance issues. The second part is who's going to help me. I'm still alive, but I need help. So there's several documents that should be put into place. A caveat: the documents I'm going to talk about are not those that you should be getting from Staples. They are not those you should be getting from Zoom, Legal Zoom. And they're not those you should be getting from the attorney that helped you with the real estate sale or the financial advisor. These types of documents are very comprehensive, in particular to aging and elder care issues, all right? Some are more complex than others. One of the two biggest recommendations I give to people is get your planning and protection done in advance and get it done by somebody experienced that knows what they're doing so that you don't have to redo it later in a crisis, okay? So when we're talking about the documents of getting people to help or allowing people to help, they run the gamut from financial needs to care needs. Sometimes you hear the phrase advance directive. So that's kind of what we're talking about here. On the financial side, there is a document called the power of attorney. I cannot emphasize how important this one document is. It may be the most important document in a person's plan. Therefore, like I just said, it needs to be done correctly. It needs to be done comprehensively. Not a week goes by that I don't sit with a client where they think they're fine. I've got my power of attorney, but it's missing all of the appropriate asset protection and income protection language. They got it from LegalZoom, or they got it 20 years ago, or they got it from the real estate attorney, or they don't have a power of attorney at all. So a power of attorney is where you can appoint one or two, hopefully not three, but one or two people to handle your legal and financial affairs. It has to be a durable power of attorney, meaning it's not just valid while you still have mental capacity, but it remains valid even if you should lose mental capacity. That's what durable means. In fact, it also has to be modified or expanded. All powers of attorney that elder care attorneys and estate planning attorneys do are expanded to be made more comprehensive. The form that you get at Staples or LegalZoom is the form that the New York State Legislature created to say, here is a good template. And then it's up to the family, hopefully not, but hope to the experienced attorney to help expand it to their particular situations. And again, it's where you can appoint somebody to handle legal and financial matters. If you have capacity, you can handle your affairs. If your capacity starts to dwindle, then that's where your power of attorney agent can step in and start to stand in your shoes and handle your legal and financial concerns. It's here where if it wasn't done in advance, you can protect the family home. It's where we can shelter the income. It's where we can apply for Medicaid benefits for home care or benefits for home care or nursing home care. That power of attorney, again, is worth its weight in gold. If it's not done properly or if it doesn't exist, then the family, unfortunately, is going to be thrust into what's called a guardianship proceeding. And a guardianship proceeding is 6, 8, 10 months drawn out court proceeding. You could have 4 different attorneys involved, one for the family. The court might appoint one for dad. The court's going to appoint another one to interview everybody and evaluate. There can be another attorney for a sibling that's arguing it. It can be a very stressful, complex, expensive proceeding, all of which can be avoided if you have not only a power of attorney, but a power of attorney that is expanded and made comprehensive. Last point about the power of attorney. New York State's done a doozy on us over the years. They've changed the form several times. The last time they changed the form was 2009 and 2010. Well, they're changing it again in June of this year. So there will be a new, what they're saying is to be a more simplified form coming out in June. If you do not yet have a power of attorney, what we're doing for clients is getting them the current one, just in case, God forbid, something happens over the next 3-4 months. And then we're just updating it come July, August, when we have the new form in place. So the idea of a power of attorney is crucial, all right? I can't stress that enough. The next document that we like people to have done in advance is what's called a healthcare proxy. You've heard of this before. We sometimes see clients come in with a healthcare proxy that's 4 pages long. We see clients come in with a healthcare proxy with living will language built into it, and I'll talk about that in a moment. Or we see clients come in with healthcare proxies that call it a durable power of attorney for healthcare. All of those things are not needed, are inaccurate. New York State very clearly created, again, a statutory template. It's what's called the healthcare proxy law. It's meant to be a page and a half that simply states, I appoint this one person. You're only allowed to appoint one person at a time on a healthcare proxy. Not like the power of attorney for finances, you could do more than one. The healthcare proxy is one at a time to make decisions for you if you can't make the decisions yourself. If you're able to make your decisions, then you do that. The proxy is only effective if you can't. We've had children call us complaining, saying, Mom's in the hospital, I'm the proxy, and the nurses won't talk to me. Well, that's because mom's still making her own decisions, okay? So the proxy, again, one person, only effective if the principal who signed it can't make decisions anymore. Another very important point, as I said, it shouldn't be 4 or 5 pages long. Medical teams do not have time to digest pages and pages of instructions and directions, okay? Simple is better with the healthcare proxy. Another critique, when we meet with folks, again, healthcare proxy with living will language built into it. It's not how it's meant to be. The healthcare proxy and the living will are meant to be 2 separate documents, in my opinion, all right? I have colleagues that I know and trust that do it as one. I respectfully disagree with that. Let me talk about a living will, and then I'll explain why. The living will is not meant to appoint anybody. And the living will is not created by statute, like the power of attorney and the proxy. The living will in New York is created by a court case. And what that judge up in Westchester County said so many years ago was that in deciding an end-of-life case, it would have been beneficial if this person had a quote living will as to what type of treatments they would have liked or disliked in that situation. So from that, New York State has allowed a living will to be created. And simply, a living will is the document that says, if I am in an irreversible or incurable condition, I do not wish to have life sustaining treatments that merely prolong the dying process. As I tell my clients, in other words, if I'm going, just let me go. I don't want ventilators, respirators, feeding tubes, dialysis, antibiotics, but I do want maximum pain relief. Okay. Um, some attorneys do their living wills a little differently. I leave my living will at I want maximum pain relief, period. Some attorneys have a phrase after that says, even if it hastens my death. I talk about it with clients that want to know about it, but I think the idea of pain relief is the goal. And I don't want somebody intentionally or wanting them to be careful, so it's not not unintentional that they provide too much painkiller. So the idea of relieving and alleviating from pain, that's the goal. Now, the living will, in my opinion, should always be left at home. It's not something that should be going to the hospital if dad is going in for a hip replacement built inside your healthcare proxy. They're meant to be two separate documents. The reason I don't like them as one document is, as wonderful as doctors and nurses are, there have been studies as to what doctors and nurses believe the scope and impact of a living will can mean. And there was a study in Pennsylvania that spoke about 40% of a healthcare team misunderstood what the living will was for. And I don't want that happening to my clients, and I like them to keep as much control as possible. So if somebody you love is going into a facility, you give them the healthcare proxy. Going into a hospital, give them the healthcare proxy. I like you to leave the living will at home until it's time to talk about those issues. I don't want those issues accelerated unnecessarily. Now, as Lisa and Susan certainly have talked about for a time, there is a time to talk about those issues, and there's a time to talk about it the right way. So do that as a family, then do that with the medical team. That's my opinion, ladies. I don't know if you agree with that. But I don't want things rushed, and I don't want things removed from the families or the client's hands prematurely, okay? So power of attorney, comprehensive, durable, healthcare proxy, very important, and a living will. Now, those are the three legal forms that an elder law attorney can prepare for you. Other than that, you might see a MOLST form, MOLST. It stands for Medical Orders for Life-Sustaining Treatment. That is an active medical order signed by a doctor or a nurse that is meant to travel with the patient from hospital to assisted living to rehab to nursing home to home. It's an active order that details what the person wants when it comes to end-of-life care. There was a lot of discussion about that for years as New York was introducing it. I was against it at first, but I've gotten more comfortable with the idea of having that discussion and recording it. I will say flat out, nothing beats, in my opinion, having a healthcare proxy agent that knows you and your wishes, who can make a decision on the spot based on all of the relevant factors. So I like the healthcare proxy as really the premier way to handle these concerns, okay? Another document you might see is a DNR or a DNI. Again, medical forms, not legal forms. Whenever I mention a living will, the client usually says, oh, the DNR. Different. So similar, the living will can lead to a DNR, but the DNR is the form, it stands for do not resuscitate, and it simply means no cardiopulmonary resuscitation. So a DNR means no CPR. There are many reasons to have a DNR, and there are many to not have a DNR. Again, to be discussed with the family, to be discussed with your advisors, to be discussed with your medical team, and so you can make your own personal decision. DNI is do not intubate, which leads to ventilators and so forth. All issues you should have discussions about and be aware of, especially with the pandemic that we've lived through. So again, when it comes to planning, protection, and care, we've been doing it for a number of years. We're here to help. Ladies, and any questions about what I've shared thus far?
Oh, I think that you've really made a lot of this more clear than it had been to me in the past.
Good.
And I know most of those documents. Could you explore a little bit longer about legal guardianship and all? There are people who are sort
Sure.
of on the fence about when somebody really is able to make decisions and all and take care of themselves and when they're really not. Could you do
Great.
that?
Yeah, good question, Lisa. So in an ideal situation, like I said earlier, an individual or a couple, a family plans in advance of any type of incapacity concerns. And if that's the case, then you will have, if you go to the right place, the right firm, you'll have a durable, modified, comprehensive power of attorney for financial decisions. That is typically the priority when it comes to incapacity versus the healthcare decisions. It's just as important in my book, but let me share why it's a little bit less, is that in New York State, if there is no healthcare proxy, we do have the Family Healthcare Decisions Act, which is a default, and it'll appoint a spouse as a decision maker if you can't do it yourself, then children. So there's a hierarchy. Now, if you don't agree and want that person to make the healthcare decisions for you, then you most certainly should have that healthcare proxy with your priority of decision makers. Okay. So if those documents are done in advance, then the issue becomes, well, dad is slipping, dad may or may not have a diagnosis. When can we step in to help? So a power of attorney doesn't have a proactive responsibility. They're not liable if they don't act, but they should. I mean, your parent or spouse trusted you to help. Now, children or spouses will say, but my husband still takes care of everything and he insists on taking care of everything. I get it. I've been there. But with all due respect to that individual, there will come a time where that person who's been sovereign and making all of their decisions independently on their own, where capacity or abilities will start to decline. And in my opinion, that's where the trusted power of attorney agent or healthcare proxy agent, as they're declining, should increase their authority respectfully and with dignity. But they should start to step in and perhaps make some decisions. I'm not saying glom all of the control. I'm not saying put them in the back seat and move them to the attic. I'm saying start getting involved with the decisions, okay? You'd be surprised that they may actually be grateful that there's a little bit of a guidepost to help them through these issues, whereas they may have been against it in the past, okay? Now that's where you have the documents in place. If there's no power of attorney in place, or if it's insufficient, if you're looking at a 2-page power of attorney, that is not going to cut it when it comes to asset protection and Medicaid benefits. So again, if there's no power of attorney or if it's insufficient and capacity is lost.
Mhm.
And when I say that, I don't just mean a diagnosis. I mean, mental capacity is lost. There's an inability to have a conversation. There's an inability to understand the ramifications of certain actions. There's a jeopardy of them harming themselves financially. There's a jeopardy of harming themselves personally or health-wise. If that's the circumstance, then, and we can't sign documents because that capacity is lost, then the idea of a guardianship becomes something real. A guardianship in New York is not taken lightly. It's last resort, and it's where a family member would have to petition the court to be named guardian of either the person for healthcare and or the property for financial matters. And as I shared in the beginning, you can have several attorneys involved. It could take upwards of a year. It could be very expensive and very stressful. You don't want that guardianship to ever occur. How do you avoid it? By having the right comprehensive documents in place. So hopefully that answers your question, Lisa.
Wow. Brian, I can't even tell you how clear you are. I listen to a lot of different attorneys, and it somehow I'm always confused afterwards. This
Well,
was
thank you.
very clear, and I appreciate that.
Thank you. My pleasure.
Yeah.
I think that it'd be a good idea now to at least put up your contact information for
Oh,
everyone,
sure.
just so
Sure.
that
Let me
Oh,
see if I
to
can-
absolutely.
consult with you.
How's that? Did that work?
That's perfect.
Wonderful.
Okay,
Tully
good.
Law Group. Brian
So-
Andrew Tully. Yes.
So
Right.
we're right on 110 in Melville. We've helped families Manhattan, Westchester, Dutchess, Staten Island. We've helped families Mattatuck, Hamptons, Riverhead. It's the whole gamut. All right. So the work that we do, I'm very proud of it. There's a team of 17 of us here, and this is all we do. We help families plan and protect. The way I put it is we help families protect the most assets. We help families get Medicaid to pay for the care, and we help families get the best care possible wherever they are. So if that's appealing or something that can help you with, please reach out. I'd be happy to talk to you.
Great. Also, right now, are you
Yeah.
seeing people in person? What are you, how are you managing?
So I've been here every single day. The nature of our firm, because we spend so much time on the care aspect, we haven't stopped. The myself and one other employee were here every day during the pandemic, helping, fielding, shuffling papers, while the vast majority was remote. We weren't seeing clients for all of last summer. Spring and summer, we started seeing clients for, distant, socially distant, masks, visors, and gloves for signings. I'd say towards the end of the summer, and we've been full blown ever since the fall of last year. Again, all protocols. We got plexiglass, we've got offices, we've got distancing, and we do all we can to make sure our clients are safe. We have the questionnaire, we've got the temperature when people come in. If somebody's comfortable with Zoom, I'm still doing, probably 5 or 6 Zoom consults a week, but we're also probably doing 5 or 6 in-person consults. So it's been a long road, but gratefully we're here and we're open. Interestingly, I have colleagues that, very interestingly, slowed down. As an elder law attorney with all that was going on, I'm surprised some colleagues slowed down. I'm surprised some colleagues let people go. I'm surprised some colleagues cut salaries. We hired 4 people and doubled our office space. Last year was a very busy year for us because of that life care planning service, where we are advocating for the clients every step of the way. So I'm very proud of that.
Wow, that's really amazing. And I'm telling you, to know Brian is to like and trust him. I've known him, I've spoken with him several times, and the life care caring plan that you offer is really comprehensive.
Thank you.
And it really envelops everything that you need in your life, everybody. So please reach out to him if any
Thank
of
you.
these issues are a concern for you right now.
Wonderful.
Brian, we really, really appreciate you being here today.
It's my pleasure.
Thank you.
Thank
So
So
important
amazing.
for everyone to really think about.
Good.
And it doesn't have to be something at the end either. Planning is so important.
It doesn't. That's
No,
right.
as we know, Lisa, pre-planning helps everything, every aspect of your life, and this is a big one.
Yes.
Yeah.
Yes.
Yeah,
So
you
we're grateful
cross
to
this
have
off
you.
you cross this off your list, you do it right, you're not gonna have to worry about things for a while.
No, big weight off your shoulders. Absolutely.
Thank you so much,
Well,
Brian.
my
Great
pleasure.
talking to you.
Thank you,
you.
Brian.
You're
Bye.
welcome. Bye-bye.
We're-
Okay.